So, as I was saying before, we are very close to the end of 2025. I'm almost tempted to say 2026. So we have just a few more Mondays left. We intend to go up to the third Monday of December because the following ones will be full of holidays, and then we resume in the new year. Welcome, everybody. Welcome if you're here for the first time or for the nth time. This is Power Monday. We are here simply to learn, to grow together, to connect, and to start the week in style, to start it on a powerful note, to get the fuel for the next 7 days plus, to learn something. I was taught that the moment you stop learning, you stop growing. Yes, you stop learning, you stop growing. So we must always be intentional about learning. We must take steps to learn. And that's the purpose for Power Monday. We've been there for 5 years. We just celebrated the fifth birthday. And I was actually checking the videos for the first videos that we did, because I mentioned during the dinner that if you look at them, you may not believe. And I will share some of them. They are quite exciting, quite an inspiration, because you can see, we are told to know how far you've grown. Just check how far you come from. Check where you are sometimes back. Then you will be able to know and understand. So welcome, and we appreciate you. As some of you already know, we meet every day, every Monday, as long as it's not a public holiday in Kenya. We use the same link, we meet the same time, and we discuss different topics. And so, and we also have a WhatsApp group through which we continue to connect, grow, and interact, share ideas, get to know each other. We have meet and greets, and the next, of course, not meet and greet. Then the coming one is not a meet and greet; it's a charity, which will be on the 6th of December, and all are welcome. So let's have a poem. If it exists, I hope it exists. The way you look seems like it exists. Yes, and then we move on. Thank you.
Yeah, good morning. It's a beautiful Monday morning. We are almost doing 52 of 52 of 2025, and we couldn't be more grateful. Thank you so much. It's another beautiful morning from County 046. And today I just want to ride into divinity and say that I will speak of the goodness of the Lord. It's a poem titled, I'll speak. I'll speak of its goodness. I will speak of his mercies. I will speak of his soul. I will speak. I will not fear. I will speak of the kindness that I've been told. I will speak. I will speak so fiercely. I will speak of his power that is so divine. I will speak, and I will say that the Lord turns water into wine. So I will speak, I'll not fear. I will speak of his saving love. I will speak of everything that is so thrown above. I will speak of the Lord. I will speak of his tender care in every burden that is in here. I will speak that sorrow will leave. I will speak of the goodness of the Lord. Thank you.
Thank you. Thank you so much, Dr. Lucita. We'll speak of the goodness of the Lord every morning. His mercies are new. So we shall speak of his goodness. Thank you so much. Thank you, OPP, for holding him. Today is that day where, a lot was happening. No, a lot was not happening. I just overslept. But I'm here.
Now we know. You always.
No, I overslept. I overslept, but you slept and we missed the whole session. I overslept for how many minutes? 3 minutes. So do not even try to
No,
blame me.
I'm
Do
told
not.
ladies, I'm told ladies
No.
don't forget. Something that happened 5 years ago. You keep
And I intend to
Okay, let's
remember for
go.
the next 50 years. I intend to
To
remember
fear
for the
women
next.
with remembering.
Okay, thank you so much, Dr. Lucita. That was such an awesome, awesome, awesome poem. Thank you for reminding us of his goodness every morning. His goodness is new and his goodness abounds every morning. Asante sana. So I call upon Mercy Okoth, who is going to introduce the guest speaker of the day. Mercy.
Good morning, Power Monday.
Good morning.
Another beautiful Monday, and I'm happy to see you all. I'm still recovering from Power Monday at 5, 2 weeks later. So yeah. So when you see me smile a lot, know that I'm still there. Thank you for giving me the privilege to introduce the speaker of the day. And I'll dive right in. Our speaker today is none other than Jackie Awuor. Jackie Awuor is a human resource and organizational development consultant with over 15 years of experience spanning the private, public, and non-governmental sector across East Africa. She has practiced as a human resource manager before settling fully in consulting. Currently, Jackie serves as a managing partner at Falcon Insights Global Consulting, where she leads assignments focused on organizational design, culture transformation, performance management, and strategic business development. Her work integrates people, system, and strategy, ensuring that institutions not only have the right structure, but also the right culture and leadership to deliver results. Over the years, Jackie Awuor has had the privilege of working with a wide range of institutions, from government agencies and international organizations to private enterprises, helping them align their people, their processes, and strategy to achieve sustainable performance. Wow. Jackie is so passionate about building institutions that work, helping organizations design effective structures, nurture productive cultures, and empower people to perform at their best. It is this passion that continues to guide Jackie's work in organizational transformation and leadership development. Wow. Ladies and gentlemen, let's put our hands together and welcome Jackie Awuor. Karibu sana, Jackie.
Thank you, Mercy. Thank you for the introduction. You know, when someone is reading about yourself, at times you wonder whether is that me. But I'm glad to be here today. I'm glad to share, and I'm glad to talk about the small things that we take for granted. So the matter employment and contracting can be a full day session, but today I'd just like to focus on the fine prints that make a difference. And I will be speaking from the lens of both an employer and an employee, because we both have certain elements that we need to have in mind. So, as I start off, I wanted to just bring to your attention that, or ask a question. Did you know that over 60% of workplace disputes arise from unclear or poorly understood contracts? And this statement is loaded because when contracts are not understood, then you're starting a relationship from a point of we are not clear on our expectations, both sides. So today, I will be focusing the conversation around unpacking the key elements of employment contracts, highlighting the rights and obligation of both parties, and also just talk about how to promote fair, transparent, and legally sound employment relationship. Some of us here could be business people, and you could be thinking that, I'm too small to start worrying about contracts. Some of us are employed, and we live in a country where unemployment is a big issue. So at times when someone sends you a contract, very quickly you look for the pen. So what is a contract really? A contract is a mutual agreement that defines expectations and safeguards interest. And when you're talking about interest, you're talking about interest of both parties. So every employment relationship, written or verbal, constitutes a contract. The people we employ in our houses, that's a contract of employment. The people we engage in our different enterprises verbally, that is looked at as a contract. So there are different types of employment contracts. There's some permanent or open-ended. This is where the famous term of permanent and pensionable. We have fixed term contracts. These are contracts that are timed. It could be 1 year, it could be 3 years or 5 years. We have casual or temporary contracts, and this has landed many people in problems because we need to clearly understand who is a casual. And then we have part-time or consultancy-based. So I'd like to ask us, how many of us have actually read our employment contracts word to word before signing? Maybe you can just put a smiley in the chat for me to see the ones who just grab a pen and sign without reading the fine prints. Now, employment relationships are actually guided by 5 different laws. And today I'm only going to focus on one, which is the Employment Act, because this is where the fine prints of how a contract should look like are laid out. So, and when I'm going through these elements, I have actually seen contracts that are not well written. And you see, when a contract is not well written, at the point of litigation, that is where you start seeing the glaring mistakes. I always say an employment relationship is like a husband and wife relationship. When we start the relationship and everything is going on well, we are all happy. But when things go haywire, that's when you start wondering, how did I even see these no's? How you start wondering, how did we even get here? So it's always good to be safe than sorry. OPP is smiling. So coming back to the key elements of an employment contract, number one, and this is actually specified in the Section 9 of the Employment Act. The employment contract must have the name and the address of the employee, the name of the employer, the job description of the employment. And the job description, basically, you're laying down what do you expect the person to do. The date of commencement of the employment contract, the form and duration of the contract. So is it a permanent or pensionable? Is it a termed contract? Is it a casual? Is it a 1 month? The place of work, the hours of work, as per the labor laws, they're agreed or recommended, or they laid down, let me use the word laid down, the laid down hours of work is 48 hours every week. And after 48 hours, a person is entitled to 1 rest day. And this 1 rest day can be Sunday, can be any other day of the week. But here, somehow, we always believe that we must all rest on Sunday. The contract should also include the remuneration and the intervals within which the remuneration will be paid. So you will see clauses in contract saying that your salary will be paid at the end of every month and to your bank account, terms like that. As I continue, you need to also include entitlement to leave. What happens when a person is sick? So in terms of entitlement to sick leave, pension, if there's pension or you're in pension schemes. Right now, I know many employers have transitioned fully to an SSF because they're currently competing with the pension schemes. The length of notice, and this is a very critical one because that separation clause must be there. And where the employment is not intended to be for an indefinite period, the period for which it is expected to continue. Okay. As I come to the last section on the key elements, and whether the employee is required to work in different places. So it's always important to note that our headquarters is in Nairobi. However, you will be required to work at this place and this place. That is clarifying expectation at the get-go. Lastly, where an employee is required to work outside Kenya for a period of more than 1 month, it's important that you indicate the period, currency in which the person will be remunerated in, and any other benefits and any terms of conditions that are specific to an employee who is working out of the country. So as you go back and look at your contracts, please ask yourself, at the bare minimum, are my contracts covering these key elements that I have highlighted? So which are some of the mistakes that I have seen? It's important that, number one, it's important that you think about contracting as setting a very good foundation. And some of the key pitfalls I have seen is vague job descriptions. I know for a fact that when you're starting out, you always you try to find the affordable resource. You want to maximize on what everyone is doing. So, but at times you find that job descriptions are not even clear. And when you have vague job descriptions, that means that you haven't clarified the expectations fully. So even from a point of pushing for performance or productivity, how do you do that when the job descriptions are not clear? The other pitfall is undefined probation or renewal terms. So you have a contract, it doesn't have a probation period, and probation period is given at between 1 to 3 months, but you cannot have someone on probation for more than 12 months. After 12 months, you need to make a decision. Do I want to have this person on board? The other thing that I have seen in many contracts is absence of termination notice clarity, whereby you're not specifying that upon exit, what notice period should the person give, non-disclosure of benefits or deductions. So if you do not disclose, then where there's a vacuum, people fill it in with whatever facts. Unfair clauses in terms of termination, where you're not giving the employee a right to also say, for example, resign. And then failure to issue written contracts. When you're thinking about labor laws, contracts can be written or can be implied. If you don't have a written contract with somebody, and you find yourself in a litigation, the fact that you've been paying them a salary at the end of the month, that is implied contract. So if you're calling them a casual, and yet you've been paying them for 12 months, every month, that is an implied contract. So in your head, you might be thinking that this person is a casual, but in real sense, they're not. So when contracts are handled properly, for the employers, it ensures Compliance, it reduces litigation risks, it sets performance expectations. And you see, when you set performance expectations, then you're also able to manage the team. You're able to actually bring out the best in people. When you look at contracts from an employee's lens, it ensures clarity, fairness, and protection of rights. We need to know the things we are signing on to because they might actually help you to know how to conduct yourself at the workplace. For instance, I'll just give one example. Many employees do not know that just absenting yourself from work for just one day can amount to summary dismissal. That is something they do not know. So you find yourself, you're not following the right procedure, you're not coming to work, and then before you know it, your summary dismissal. And you see, summary dismissal basically it means you're fired without notice. You're not going to be liable for any payment. So let's look at this from both employer lens and employee lens. Now, I want to highlight some of the obligations of employers, and I'll do the same for employees. Employers have legitimate rights that allow them to manage their business effectively, maintain discipline and productivity. So when you're designing that contract, you need to ask yourself, what clauses must I have in the contract to help me run the business properly and to help me run my enterprise properly? So, and as an employer, you have a right to assign duties, set performance standards, and direct how work should be done. So no one should come and tell you that I want my job description to look like this. As an employer, you can assess performance and reward or take corrective action. You can take disciplinary measures for misconduct or poor performance, but this must be done through following due process. You can enforce confidentiality, non-compete clause, and intellectual property clauses. So as you're designing those contracts, you need to ask yourself, do I need to have a non-compete clause? And for how long? And does it make sense? You must always have a confidentiality clause in your contract because then once the person has signed the contract, then in the event that there's a breach of confidentiality, then you can take it up legally. Employers they can reorganize departments and basically structure the organizations the way they want. Further, employers also carry a duty of care and legal responsibility to ensure fairness, safety, and compliance. One of the things that have landed people in hot soup is that the burden of proof in any litigation, it lies with the employer. So if a member of staff came and said, took you to court and said, since I was employed, I've never gone on leave. And leave entitlement is 1.75 days for every month worked, then it's you to prove that they actually filled in a leave form. So when people just call you and tell you, boss, today I'm not coming to work, please make sure there's documentation because in that way, you're just covering your back. So as an employer, you must issue a written contract. You must pay the agreed wages or salary in full. You should not discriminate because that is one area where, again, I've seen a lot of gaps. You must allow annual, sick, maternity, and public holiday leave. Some of us say, I'm too small, I cannot allow someone to be away for 3 months. But what you need to know that in the event that they take it up, you'll have a case to answer. Upon exit, an employee is entitled to a certificate indicating employment duration and position. So this can be just a certificate, and you can also use a recommendation letter. Employer must remit an SSF, SHIF, and pay as required by law. So when you're thinking when you're wearing the lens of an employer, Fulfilling this obligation, it builds trust. It helps to protect against costly labor disputes because those things can be tiring. And at times, I have seen claims or awards of up to 3 million and even up to 10 million. So when you think about on the employee side, you're entitled to prompt and fair pay for work done. And when you're thinking about fair pay, there's something called regulation of wages, which actually sets the minimum wage. Every first of every Labor Day, Atoli and his team will make declarations about if there are any adjustments. So after every Labor Day, please follow up to find out if there's a new regulation of wages that has been gazetted, because you might be going against the what has been set as minimum wage and you do not know. Employees must not be exposed to physical, mental, or emotional harm. Employees are entitled to a bare minimum 21 days. And how this 21 days is calculated is 1.75 days times 12 months. They're entitled to rest days. They're entitled to public holidays or compensation of the same. And in compensation can be in monetary terms or in time. Employees are also entitled from protection from discrimination based on gender, age, race, religion, or disability. So when you're designing even your HR manuals, you need to think about, are there elements there that could point towards discrimination? Employees have a freedom to join or form a union, and this is without victimization for those that this is applicable to them. They cannot be dismissed unfairly or without a hearing. They're entitled to know contract terms, company policy, and any performance expectations. So if employee comes and says they don't have clarity on contract terms, then it's up to you to actually prove that they were clear on expectations. In fact, I think there's a section, still section 9 of labor laws that even said, if the employee is illiterate, you need to explain to them the contract terms in a way that they can understand. And if they cannot sign, they can even put in their thumb as a confirmation that they have understood. So further, when thinking about the obligations of employees, they must perform assigned duties with skill, diligence, and care. They must follow lawful and reasonable instructions. They must not misuse company information. Regular attendance unless lawfully excused. They must uphold ethical behavior and upon termination, return company assets. So if you resign and you run away with the assets of your employer, please know that they can come for you legally. When we understand our obligations as employees, this strengthens professionalism, employability, and trust with employers. And this can also lead to career growth and stability. So people always feel like labor laws are more pro-employees than employers. Where we miss it is the burden of proof. If you go through the labor laws, they're actually structured to protect both parties. But the burden of proof is largely placed on the employer. So that is where we drop the ball, because when a litigation happens, then you realize you have no way of proving certain things. So I wanted to just highlight a few cases that were recently in the court. So this is a case between Saika Manpower and some Iteba and 9 others. They were employed. Actually, the person who took up the case No, is this, I had three cases. This is the Unga one. No, this is the Unga one, where a casual was employed on a temporary basis for 13 years. So the employer knew that this is a casual. And upon, I think about 12 years later, very quickly they tried to regularize, and by giving them a 1-year contract, and then they terminated. So the person took Unga to court, and Unga denied that the contract was wrongfully terminated, and it refused to pay his dues. Actually, they said that this was a casual. Remember, this employee, in as much as they were being termed as a casual, they had already been included in the gratuity program that was exclusive to permanent staff of the company. Remember when I talked about implied contracts? So the employer knew that this person is a casual, but legally the person was being looked at as a permanent staff. And therefore, they were entitled to things like notice pay and any other entitlement that was being given to permanent staff. At the end of it all, and largely because of absence of records, the employer was forced to pay for about 500,000. They were actually forced to pay for leave for all those years because they didn't have proof. And they were also forced to pay to give the person notice pay. So one common pitfall is engaging people as casuals as a way to avoid, as a shortcut. Please note, this can land you in trouble. OPP, please let me know how I'm doing on time.
You
Okay.
are good. Yeah.
Yeah, so this was actually the case I was talking about. Now, the other case was, let me just read this. Just a second. The second case was in Great Lakes Trans Limited versus Robert. So what happened in this particular case is that Robert had started having issues, disciplinary issues with the employer. And when he was given a notice to show cause, he disappeared and stayed away from work. So the employer deemed the employee a deserter because they didn't show up and didn't follow up with any documentation. And then the guy showed up after some time to claim his dues. The guy was actually awarded because there was no closure of employment relationship. So the employer's actions did not meet the threshold for a fair termination, and the court actually observed that in circumstances, the employer ought to have issued a formal notice of termination to conclusively bring the relationship to an end. In this particular case, the person actually deserted work, but the burden of proof is what actually landed the employer in trouble. So what am I saying? Documentation is critical at whatever level. Make sure that when drafting and managing contracts, use templates that are reviewed by legal or HR experts so that you ensure that your contracts are watertight. Conduct orientation on contract terms, review and update contracts regularly. One of the things that happens is an employee joins as holding a certain role, and then they grow in the business. But when you go to the employment file, they still have the contract for when they join. So best practice is that when there's any change, please ensure that it is documented and filed. That way you have your paperwork sorted. For employees, read and seek clarification before signing. From what I have highlighted, you might find that actually some people have signed on to contracts that are not designed well. So always ask for a signed copy and make sure you keep a signed copy. Some HR professionals or some business people have this tendency of denying the staff their records. So please note that employees are entitled to view whatever is included in their files. And one of the things that you should always do, you see that contract, always have down there a statement saying, I, so and so, confirm to have read and understood the contents of this communication. That will come in handy as proof that the employee actually understood. And now for you as an employee, before you commit to sign, however desperate you are for a job, please know your rights and obligations and make sure that you ask any questions. Let us not be lazy. Let us seek knowledge and know what we are signing up for. And HR professionals are facilitators, not enforcers. They are meant to ensure that there's fairness and there's documentation integrity. So some of the emerging trends that we are seeing that we need to take into consideration, even as we are talking about contracting, we are seeing a lot of freelancing and gig contracts. We are seeing remote work and hybrid terms. There's a big focus on non-discriminatory and gender-sensitive clauses in contracts. There's data privacy consideration. In fact, you need to revise your contracts to ensure that you're covered as per the Data Protection Act. And we're also seeing sustainability and ESG clauses in employment contracts. So this is where we are headed in contracting. As I come to an end, I'd want us to maybe I'd like to ask a question, and I'd like to ask two questions. Questions to reflect upon. What's the most confusing part of a contract you've encountered? What do you think is missing in most employment contracts today, based on what I have shared? In closing, a good employment contract protects both employer and employee. It builds trust, accountability, and alignment. Let us not make contracts just legal documents, but tools for collaboration. An employee and employer relationship is one of collaboration. And when both sides understand the contract, the workplace works better. Key lesson for me and key learning that I'd want to pass on to you, prevention is cheaper than correction. So at Falcon Insights, we specialize in HR compliance, organizational development, and business advisory services. So we can also be there to help you go over your contracts. And since it is Black November, we are offering a free 1-hour consultation just to check whether you're compliant. Otherwise, that is all from me, and I welcome questions. Over to you, OPP.
Thank you very much. Thank you very much. I think I love that voice. I wanted to listen more and more. Yeah, simple, flawless, no hitches. Whichever God you are praying, that's the one I really want to worship. Yeah.
Okay.
Rajwai asked the first question. You said there are 5 laws governing employment, but today we focus on Employment Act. What are the other 4, and how can we stay in compliance with the others, both as an employer and as an employee? That's one question. Maybe you can also.
Yes. Rajwai, that's a very loaded one. So I will tackle just one part. We have the Employment Act, we have the Labor Relations Act. This is where now the unions come in the right of employees to form unions. We have the occupational safety and health. How do you need to comply as an employer? What are the elements of occupational safety that you must have in place? We have labor institutions, and then we have work injury and benefit. So if I'm to go through each and what you need to do to comply, it will take us a full day. But maybe at a very high level, when you're thinking about Work Injury and Benefits Act, that is WIBA, as an employer, you need to take insurance. And these things are not cheap because an employee is entitled to compensation when they're injured at work. When we come to OSHA, it talks about OSHA is a short form for Occupational Safety and Health. It talks about the kind of having even a safety committee in-house. How do you need the training around first aid and those kinds of things. So I may not be able to go over all of them, but those are the 5 major ones or the 5 acts.
Wow. Thank you. Thank you. You know, some people are now starting to confuse. Are you a legal person or a HR person? It seems like those
I
things
am a
intermingle.
HR person, but I have been beaten severally.
Yes.
So you learn to know the areas of exposure.
Beautiful. And it's good to mention that Falcon Insights Global Consulting Limited was one of our sponsors for the dinner. And that's how come the dinner was successful. They were able to come in handy and help with a couple of other things, sponsoring. So somebody has said, Martin Olo, share a sample typical good contract. Well, I think the idea is to share a sample template. And then Dr. Melvin is saying, great presentation, Jackie. Are labor disputes amenable to ADR, that is alternative dispute resolution? Number 2, some hospital groups are part-time or locum hiring doctors and dentists without official contracts. Is this legal? Or what do you say about that? So perhaps you can speak to those two.
Yes, contracts, litigations are amenable to ADR. And in cases where I have been requested to support a litigation, I look at the facts and just advise the employer, let us take this out of court because there's no way we are winning this. So yes, they are amenable to ADR for as long as both parties are agreeable to what is on the table. As per your second question, that is illegal. And I will tell you, Dr. Melvin, that if employees were to really decide to take employers to court, we are just a peaceful lot. The labor courts would be very busy.
I can see. Yeah, I think we are a good people. We just like good relationship. Yeah. Somebody has said, oh, well, Modesta said, great presentation. Grace Andeso is taking notes and she's requesting you go back to slide number 20. She even marked them and counting them. This is very interesting, Grace, full of grace. Then we have uh, Shiro Mugidhi, great presentation, awesome presentation from Louisa, excellent clarity presentation. Please help with the template. Okay, that is also talking about template. If dismissed by an employer, is there a duration before you take the matter for litigation? Maybe timeline. So maybe if you stayed this long, it is expired or it's overtaken by events, or maybe a time that you need to wait before you seek legal redress. Maybe that is what Shiro is asking, Shiro Mugithi.
So you can seek legal redress within 3 years. But for employers, you need to maintain the documentation for 7 years. So when a person leaves, please do not throw away their file, even if you didn't like them.
I like the way you answer them, brief, clear. Yeah, even if we hated them and it's good riddance, just need to keep it. My friend Tenga, you can just put the question in the chat so that we manage time. And then I hope you will share this fantastic presentation. Tito, so if I have been renewing my staff contracts after every 3 months due to the nature of my business, where I hire as per a shipment, in case I'm taken to court mid the current contract, will the other expired contracts matter? I hope you got the question.
I think so. Let me try to
Yes.
understand it.
Mm.
So if you're going to be engaging for 3 months, number one, please ensure there's a break. You can even have a pool of people and you rotate. Because if it's 3 months and then another 3 months and then another 3 months, it clearly demonstrates you're trying to beat the law. You're trying to, because it shows that there's a continuous duration. Okay. And if you, let's say you've engaged them for 3 months, they ensure that that relationship for that 3 months, you've closed it, have a break, give them 2 weeks or 1 month, and then they come again.
Oh, I think that's beautiful. That's what I was asking, in my view.
Yes.
Yes, we always want to take it 3 months, so that we also stay afloat. Otherwise, the business goes under. Okay, that's
But I
beautiful.
also want to also address it differently.
Mhm.
Look at it from the business side. If you're engaging me for 3 months, there's no permanency. As your employee, I cannot plan. I'm always just there waiting for the next big thing. Even permanent and pensionable contracts, for as long as you have a very clear separation clause, you can get out of it. If the business is not doing well, you can, for as long as you separate and you follow due process. So in trying to give short-term contracts, because we are like, hey, I'm not sure, what you're also doing to your business is that you're not going to build loyalty, because you have people who, for example, if they wanted to take a loan, they can't go to the bank and give them a 3-month contract, because the bank would be like, no, this is only for 3 months. So also look at it from the point of, how do I have systems in place that help me to grow as an enterprise?
What do you mean by separation?
Separation clauses. You can either resign, you can, even you as an employer, you just give 1 month's notice, there's no business, and yeah.
Okay,
When I
good.
talk
Now,
about separation is when that relationship is ending. It can be resignation, it can be redundancy, it can be a termination, it can be a summary dismissal.
can be divorced. Okay, now.
It can be it's the
Okay.
different ways of divorcing, yes.
Okay. Now there is also this one from Ivan's Houseman. Houseman is asking, can I have a contract without reference to labor law if it is mutual and we agree we won't apply labor code?
You cannot, it's like you're asking, can I get into a contract with someone without making reference to the Constitution of Kenya? You see, the labor laws have given guidelines of how an employment relationship should be handled. So when things are working, you will be fine. But when you disagree, you cannot stop someone from taking you to the labor courts.
Okay.
So I
Yeah.
think for me, my answer to you is just to do everything above board. Prevention is cheaper than correction.
Okay. Okay. Yes, then I think this one you had spoken to. Josephine is asking, what's your take on settling out of court? You mentioned something like that. And you said that sometimes you advise your clients that let's just take it out of court. I think that was it, right?
So my take, maybe something I need to add. Remember,
Mm,
burden of proof is on the employer. So if you know
mm,
your records are in shambles and you still want to go, waste your time, engage lawyers, you'd rather just settle out of court. But
mm.
if you know you have a strong case and maybe it's an issue of interpretation, because at times in matters law, it is how the interpretation was done, what was implied. So, but if your documentation are not in place and you know that you erred somewhere, you're better off just settling the matter out of court.
Good. Well, Tito, who asked about that contract of 3 months renewable, said he agrees with you. Though some of us have been pushed by the current economy to work as per availability of product. I've burnt my fingers severally when port clearance took like 2 months, or cabs, inefficiencies took forever, and the likes, and we can relate with that. Grace has said, please speak about joint unions in relation to how employer will perceive you. I think joining unions, will you be seen as an activist? You are the politician, or you are labeled, or what? What's your thought on that?
A progressive employer will not see you as an activist because you have a right to join a union. So it's really an employee's right to join. So the thing is, you know your employer best. The other thing is, are you the only one in the company joining the union? And what are your reasons for joining the union? But you find like there are unions that cover certain sectors. You'll find there's one for people who work in the flower farms, there's one for, and then there's one that is internal to the company. So that means you're not the only one. But a progressive employer should not look at you as an activist. So it's really a personal thing on the kind of leadership that is in your company. That's what I would say about that.
Thank you. Thank you.
But legally, you're covered.
Mm. Jackie, I would like us to pause. There are a number of very good questions, but I'd like us, because of time, so that we close at 8:15, and then these people can stay behind and you answer them. They are very, very beautiful questions. What happens when an employee does not report to work, whatever, whatever? There is a question, I believe that one you covered, but there is a question to do with foreigner. What if what labor laws apply when you are a foreigner and things like that. So I think you can just wait a bit, and then we move towards the end. And in the meantime, we will move to our usual pace. And I will call Lady Noel to pick it up. Just to remind people that we have a YouTube channel I had shared there. You can subscribe so that you are able to follow this again. When you want, you can share it with other people. And we also have a WhatsApp group, and you can join. Lady Noel, go ahead.
Okay, my internet is a bit unstable. I hope you guys have not been waiting for so long in silence. So I call upon Dr. Melvin Glemmer, who's going to give us a vote of thanks.
Yes, Dr. Melvin, you can come up and pass a vote of thanks.
Dr.
And
Melvin, are you in the house?
Yeah, I'm
I
in
know
the
you're in
house.
the house. Where art thou? Okay, thank you.
okay.
I'm in the house. Okay, thank you very much, OPP and team. Another very exciting Power Monday. I want to thank Antonia as well for putting this together with Odhiambo Olale and Noel Hassani. Additionally, I want to thank every one of us who have made time for this exciting session on human resources. And finally, I want to thank our speaker today, who has surpassed our very high standards at Power Monday and given us an excellent talk about contracting in particular. And she's given us a special offer of a free 1-hour consultation. So just in case any of us needs to look over their current contracts or develop new ones, Falcon Insights Global Consulting Limited, through Jackie Awuor, have given us a special offer this November. So with those few remarks, I want to hand it back to Noel, Lady Noel. Back to you, Noel.
Dr. Melvin. Thank you so much, Dr. Melvin. Maybe we just need to pray, and then after that we can. After that, no. Before we pray, is Anthony in the house?
Yes, Antonia is in the house.
Yes, I am here.
Antonia, any news from the admin?
Yes. Good morning to our Monday team. First, let me thank our guest for today for such great insights. I just like the way you have talked to us in such a calm and composed manner. That was really insightful. Thank you, Jackie, for that. On our admin, let me remind us, OPP, I know OPP reminded us, but just to insist on the upcoming charity activity that will be taking place at the children's home. I would request us, for those who would like to support this noble cause, let us do it on time. If you have any dry materials like food stuff, I'm saying dry because we may not have enough space to secure the ones that are not dry, like vegetables. But if you have any dry food stuff like cereals, you can let me know where to collect them. I've already received clothes from 3 of our friends. So if you'd like to give clothes as well, you can let me know where to collect them. We don't want to do it the last minute. For the previous times, we've done it up to the last day. Then when we are supposed to be at the children's home, it is the time you're calling me to collect the clothes from your home. So let me know on time, if possible before December, and I will collect them so that we can have a common point where we'll be picking them to the children's home. And also, we are also giving in cash because you normally buy some of the stuff. If you're not able to produce the giving in kind, kindly you can just send your cash through the Power Monday account, and then we will do the purchase of the items. And thank you so much for your support. This has always been possible because of your givings and your sacrifices. So may God bless you so much. We're looking forward to our next one on the 6th of December. And also to appreciate you, I missed last Power Monday. I had some other engagements. To thank you all for creating time for the Power Monday dinner. That was really on another level. And we thank everyone who made it a success. Asanteni sana, and may God bless you. And I'm also sorry for not adding you on Power Monday if you had sent your request last Monday. I'll be doing it today. So if you had sent your request, you don't need to just the form again.